This will be fun. I don't know how many you'd spent time with. There's a number of companies that have moved over the last few months to from Delaware to their state of incorporation, to either Texas or Nevada. And there's also been a number of other companies that are considering this. And one of the when this happens, there tends to be these charts that the law firms produces, and like, here's Delaware on 15 issues, here's Nevada on 15 issues, here's Texas, and they're kind of mind-numbing, and they don't really give a lot of answers. Similarly, there's expert reports, which tend to reach some very high-level conclusions. But we have this great opportunity to really hear it from actual judges who are running the show in those states, and as well as leading litigator from Delaware. So let me introduce our amazing panels today. To my immediate left, we have Judge Sofia Adrogué, who was appointed by Governor Greg Abbott to be one of the first judges of the Texas Business Court. She sits in the 11th Division, which is in Houston. So that court started on September 1st, 2024. Sofia is a native of Argentina. She was a former senior trial partner at the firm of Diamond McCarthy. For over 10 years, she won all sorts of accolades there: super lawyer, best Latino lawyer, most influential lawyer, most powerful woman in law. In fact, in Houston, twice they made proclamations of Sofia Adrogué Day. So we're very honored to have you here. But probably most relevant to what we're doing, in addition to her serving as judge, she envisioned and serves as the editor of the Texas Business Litigation Treatise. Then I have Kathy Dearlove, who received her JD out here from Stanford. She's a leader of the litigation practice at Richards, Layton, and Finger in Delaware, where she's litigated some of the most important cases on the docket in the Delaware Chancery Court, Court of Chancery, and the Supreme Court. Then to my far left, the Honorable Lidia Stiglich, who was appointed to the Supreme Court of Nevada by Governor Brian Sandoval in November 2016. Then in 2018, she was elected by the voters to stay in that seat. She ran unopposed. She served as the Chief Justice of the Nevada Supreme Court during 2023. Prior to her ascension to the Supreme Court, she served for 4 years as a state district court judge. And prior to joining the bench, she was the founder and managing partner of Stiglich and Hinckley. She's admitted to practice in Nevada and California, and she received her degrees of undergraduate from Berkeley and her JD from UC Law School, San Francisco. So this is, I think we're gonna hopefully learn a lot. So let me start off by asking Justice Stiglich just to give us a sense of, one thing I want to say just as a disclaimer so everybody doesn't have to repeat it. Nothing that anybody says on this panel is being said in their capacity as a judge on behalf of their state, is relevant to a specific case that they're litigating. It's not on behalf of anybody's law firm. We're just having a conversation as some thoughtful people. So, Justice Stiglich, if you could give us just a sense of how you came to serve on the Supreme Court, and then just give us some background about the Nevada court system as relevant to publicly traded corporation. And in particular, there's 3 items if you could address. One would be the fact that even though you ran unopposed, you are elected. And I guess, as I understand it, currently it's a nonpartisan system. You ran unopposed. But we saw what happened in the Wisconsin Supreme Court race. It became very politicized. Is that ever in the background or possibly in the future for Nevada? 2, just to give us a sense of in the courts in Nevada compared to Delaware, one of the hallmarks of Delaware is what is called down there the twice-tested approach, where when looking at a corporate action, first you look at whether it's in compliance with the statute? Can you mechanically do this? And then from a more equitable point of view, for instance, you look at the fiduciary duties, which is something that's not necessarily on the books of the statute, but the courts will evaluate that. And is there room for the twice-tested approach in the Nevada courts? And then thirdly, one item that struck me is that there's a right to jury trial in Nevada, and how that interplays with business disputes or corporate disputes. That's something that I don't think a lot of corporations are used to, for instance, in their shareholder litigation. So it's a lot, but I'm sure you could give a whole speech for 45 minutes on them, but any light you could shed for us on background and just a sense would be great.
All right, well, thank you for having me, and thank you for being here in such, I'm very humbled to be here, to be participating on this panel. So I graduated let's go back further. I graduated from UC Berkeley in 1992 with a BS in business administration and emphasis on finance. I then went on to law school at UC, now SF, then Hastings, or UC Law SF, then Hastings, and proceeded to get my lowest grades in corporate law and constitutional law. And well, here I am. I don't know why I'm on this panel or how I'm in this position. But I practiced in the Bay Area for a number of years before moving to Nevada. I moved to Nevada in 2008. 2008, I started kind of brought a piece of my firm over to Nevada, and I commuted pretty regularly to the Bay Area, going back and forth. In 2012, there was an opening on a district bench in Nevada. District court in Nevada is akin to Superior Court here in California. And I put in for it. And I say that only because only in Nevada does that happen. That I moved from the Bay Area, started practicing, ended up on the bench in Nevada. The qualifications to be a district judge in Nevada are 10 years a lawyer and 2 years in Nevada, and $150. I had all three of those. So I was appointed through a judicial selection process. I got the position. Governor Sandoval appointed me to the district bench as well. He's my favorite governor, I'll say that. And then when you are appointed in Nevada, you have to run in the next general election. So I had a contested race for the district bench. In 2 years, I was elected. Subsequent to that, there was a vacancy on the Supreme Court. I took a flyer on that, went through the process again. I was appointed again by Governor Sandoval, and so got that position. 2 years later, I had to run. In 2018, it was actually a contested election. So I had to run a statewide contested election. Oh. It's a 6-year term. When those 6 years were up, I was just up in November. I was on the ballot because I was unopposed that time, just by voting for myself. I secured the position, even though none of the above always gets a pretty healthy turnout in Nevada. To be on the Supreme Court, you have to have been a lawyer for 15 years, again, 2 in Nevada, but then you have to have $300. So elections are tough because that's what you know about your judges when they run for election, and certainly it's a difficult media market to crack. So that said, you talk about why am I here? Why am I here? But business courts, and in Nevada, we don't have a traditional business court, I guess, in the same way, certainly that in Delaware, and certainly my colleagues in Texas. We have 90 district court judges in the state. The bulk of the cases are in the Las Vegas area, and that's Clark County. That's our 8th judicial district. More than 2/3 of the cases in the state generate from Clark County because that's where the people are. Business courts are judges who are selected to take on business cases in addition to their duties. So we have 6 judges in Las Vegas that also serve as business court judges, and they have a lot more discretion in terms of what they hear. So certainly derivative suits, mergers and acquisitions, those type of things are eligible to be in the business court. And you can ask for that when you file. You can be transferred to that if you file. Oftentimes, however, even though there's some exclusions, businesses like to go to business court. even when it's not a traditional necessarily business court matter. So it could be a contract dispute, which ordinarily wouldn't be in business court. But they pay the extra filing fee, and it's up to that particular judge whether they allow that case to stay in business court. The benefits of business court, and we have a small one in Reno, I think it's 2 judges at this time, are that you get the same judge. You largely avoid having to go to a discovery commissioner, so that all stays in-house, because these are things in the ordinary civil track that kind of lengthen your process or take you out. So you get that attention. So that's kind of the way we are set up. About 16 years ago, somebody asked the legislature, hey, it'd be great if we published what happens in our business court so that people can see what's happening. And we don't. We still don't. And largely what happens from one courtroom to another in those business courts is anecdotal. And it's not largely precedential because of that, because we don't have written opinions coming out of those business courts. I'm trying to think through your questions, Ethan. So
right.
jump and prompt me if let me know. It's obviously market. It's a difference certainly between that. Currently, our legislature meets biennial legislature, citizen legislature, every other year for 120 days. I know that because we've been there all week, and we sit at the Supreme Court and we watch them walk back and forth from the governor's office to the legislature, the poor dears, as they go back and forth doing the business of the state in a very short period of time. There are 3 or 4 different items that they brought up. One was trying to make the elections partisan. So that died pretty quickly. I can tell you in Nevada, judicial races and elections are refreshingly nonpartisan and honestly nonpartisan. I can tell you, having come onto the Supreme Court, it took years before I even knew what people were registered, because you certainly wouldn't know by the way they voted. You wouldn't know by the way that they approached cases, because we all do higher math oftentimes. If it goes to SCOTUS, people are like, oh, that'll be a 5, 3, 2, maybe 1. And people have an idea already of how things are going to come out. For our court, that certainly has not been my experience. It hasn't been my experience on the district bench. So I think that's a benefit. We also have pretty strict ethical rules regarding partisanship. You cannot seek or use the endorsement of a political organization. So no one can run as a Republican judge or a Democratic judge. They are non-partisan races, even though people may be registered in different ways. Could that change? I mean, we all certainly watched Wisconsin, and we don't want to be Wisconsin. That's not the way we want to manage our disputes, and we want to act. And I think the voters are very good about it. To the extent that we've had retention, people talk about maybe retention elections instead of elections. I'm not certain how other states do it. Retention elections, they're difficult. But if there's going to be an election, and I'd rather run against that dummy than this one. So if there's going to be an election, retention elections can be very fraught, because they're usually motivated.
What does it mean, a retention election? Could you just...
Where you don't have an opponent, you run, and the voters vote and decide whether to retain you.
And all you need is 1 vote.
No, you need 1 vote because we're unopposed. These are open elections. Once you're appointed and you run, anyone who meets the stringent qualifications of 10 years, $150, it can run. So some states have retention elections where you don't have the contested races. All right, so where are we?
Twice tested.
Twice tested. Is there room for that in the current statutory scheme? No. That's not the way it operates. It requires your business judgment rule, but then, of course, we require for personal liability, intentional misconduct, fraud, or criminality, essentially, or knowledge of wrongdoing. So it's interesting, though, because in preparation for this, because at the Supreme Court in Nevada, we don't get a lot of business court cases. We don't get a lot of shareholder disputes. And so we probably, our case law in that regard is pretty sparse. I'll just tell you, Nancy Drew has 175 volumes, and that's from 1930 to 2003. We've been writing since the 1800s. We have 140 volumes of Nevada law. So the exciting thing about that, of case law, so we have, I think, endeavored, and I think if you had to say what are the courts doing, the courts have endeavored to try to keep fidelity to the statutory scheme, leave that in the hands of the legislatures, certainly doing our job in terms of our application of the law, but in terms of making it, there's those opportunities because it certainly hasn't all been said yet in Nevada or done, but our legislature has spoken pretty clearly. Not that we can't consider Delaware law, but any law is not going to trump Nevada law. And any other law that may in a different jurisdiction, writ large Delaware, for instance, that would constitute a breach of fiduciary duty, in and of itself does not mean you've breached it in Nevada law. So. And then
as far as the jury trials set up, that's in the Constitution, so that's anybody can, any plaintiff, I mean, I know there's not much history of shareholder suits,
right.
But in theory, when there are shareholder suits, the shareholder could say, I want to go before a jury.
Absolutely, you have a constitutional right in Nevada to a right. Jury trial. A lot of times the way the business courts manage that or either embed the equitable pieces within the jury trial to the extent they can, so they can, on injunctive relief or those type of things while they're hearing a jury trial, or they happen before, they knock them out, and then the cases kind of slow their trajectory a little bit. Certainly you can ask for a bench trial if both parties agree, but you have an absolute right to have a jury trial.
Okay, let's go shift to Texas first a bit. Judge Adrogué, so first of all, you were appointed for a 2-year term by Governor Abbott. So if you could just give us some background on how you were selected. Governor Abbott obviously is not shy about taking aggressive public positions. Just observations on having a term that's at this point relatively short compared to terms of other judges. To whether there's room for this twice-tested approach in Delaware. And then what role does Delaware law play in Texas? You know, there are cases in the case law from the Texas Court of Appeals saying the Texas courts look to Delaware on matters of corporate law. And then finally, the jury trial concept. I know many people here are probably too young to remember, but there is, I think, the famous Pennzoil Texaco jury trial, which resulted in over $10 billion of damages awarded against Texaco for failure to perform what many thought would be a non-binding letter of intent. And I think that left a lot of corporate boards a little scared about being before a Texas jury. But give us some background first. I think if we could start and tell it, because the business court is very new. It only started 7 months ago. So if you could tell us how you became a judge and how the court works.
Thank you very much. Honored to be here. Thanks to Freshfields. Thanks all of you. And very excited to have started working with Berkeley. I had the luxury speaking with the students yesterday, and honored to meet you, Justice, and an honor to meet you as well. So a couple of things. You've asked for what could be about 45-minute worth of dialogue. The Justice did an incredible job. We'll see if I can emulate. I'd say at the outset, in terms of the state of Texas, you know, we've got a business court. We were known for its business, the 8th largest economy in the world. We were known for litigation. We've got over 1.6 million lawsuits just in 22 alone. We are the most litigious state in the country, second most litigious being Florida, and it's a margin level difference of about 35-36%. We were, though, not known for a business conduit venue, i.e., if you had sophisticated commercial litigation, shareholder derivative governance issues, where could you turn that there would be some ability, given the amount of the caseload, to get streamlined, sophisticated attention to the matter? This took more than 20 years of back and forth with great lawyers on the plaintiff side, defense side, to try to, in essence, come up with a compromise. The compromise was the business court. There's 10 of us from across the state: Dallas, Houston, Fort Worth, San Antonio, Austin, 2 per division. Cumulatively, there's the potential for 11 divisions. The rural cities may get courts in the next legislative cycles. Our legislative cycle is every other year. They're going to meet through early June unless there's a special election. I had been practicing law, like many of you, working with general counsels, investment bankers, and others for 30 plus years. Clerked on the Fifth Circuit, started my career at a litigation boutique called Sussman Godfrey that now has been in a fair amount of press. So I've done plaintiff and defense work. Interestingly enough, there's two of us in Houston. Please come join us, come see us. Judge Dorfman, he also clerked on the Fifth Circuit. We both also started our career at Sussman Godfrey. I was fortunate enough to be asked by LM about 14 years ago to create a business litigation treatise. It's almost 2,000 pages, 25 subjects being covered by some of the great lawyers from across Texas. So we have a system now that we've got the business court. There's 10 of us. We are technically a trial court judge level. Why do I say technically? Because it's a hybrid role. We are required to do opinions. So we've got a significant docket, not significant, not in the thousands of cases like the civil district court judges do, but we have a significant docket given our expectations so far. We've been open for business, Ethan, and thank you again for everything, is absolutely correct, for less than a year, but we are busy. I ended up having the first hearing of all business judges across the state. Happens to be a case that is also pending other ramifications of it, permutations in California federal and in Delaware Chancery. Autonomous vehicle, when it went public, valued at $8.5 billion almost, and delisted. Issues of trade secrets and business disputes, co-founder disputes. I'm addressing the trade secret ramifications of it right now. Very significant cases, required to write opinions at the same time. So in terms of, I'm trying to give you a little bit more background so it's as if you're getting to meet us. We consider ourselves a business court singular. So we really do see us as a brain trust. If you were to ask how you would describe the 10 of us, half of us have been on the bench before, some trial and court of appeals. One was even a county commissioner, and half have not. Most of us tend to have at least 25 years experience. You have to have at least 10 years in business litigation, commercial, sophisticated litigation. And I would actually see us as I would say highly cerebral, nerdy. We get that we're being scrutinized. We appreciate, in quotations, understand the hyper scrutiny. And we want to do everything we can to get it right. We want your business. We also appreciate we have concurrent jurisdiction. Now, it is limited. What does that mean? I'm trying to go as quickly as I can. Cognizant, I have 4 other subjects he wants me to cover. $10 million qualified transaction or $5 million, and you have to meet the specific governance dispute criteria. It's all about shareholder derivative issues. We would qualify internal governance. I don't have the time to go through the statute. Publicly traded companies also, they don't have the monetary demarcation, but you do have to qualify and make sure it's publicly traded and a governance issue. Part of the discussion with legislative and the plaintiff and defense bar, we're not doing personal injury, we're not doing malpractice, medical malpractice. That said, I will say there is a real interest and trend with this legislative session to go from 10 million to 5 million and augment our jurisdiction. It appears that so far the lawyers and others have been happy with what's transpired, that we're actively listening. We're trying to move cases and do the best job that we can. So our jurisdiction may increase. We may also get more judges. Houston has more than 50% of all the cases across the state. 25% of them then goes to Dallas and the rest in the other venues. What started happening is equalizing the docket. If your case is one of the counties that we're responsible for, which is about over 6 million people, you'll be in the venue where you want it to be. More likely than not, you get a Houston judge, but dependent upon our caseload, there has been some coverage by San Antonio, Austin, others because we are considered one court. That started to happen. Okay, Ethan, trying to answer your questions. Yes, 2 years. Yes, Constitution. We've been asked, are we concerned? Do we get calls from Austin? No, we're not concerned. And I only mean that to say, I will do the best that I can. I practiced law for 30 years before. If I have to go back to practicing law, I will. I will do everything I can, adhering to the jurisprudence and with the hands I'm being dealt. We feel very autonomous. We are one court. We try to do one brain trust and do right by the business of the litigation that's before us. In terms of the Delaware, in terms of the jurisprudence of Delaware, we all appreciate the import and gravitas of the Delaware Chancery, the years it's been in existence, and even the commercial, the trial court, 2020, the commercial law aspect since 2010. We are just starting. They have a forest of jurisprudence. We, of course, have to adhere to the jurisprudence of the state of Texas first and foremost. If it's incorporated in Delaware, Delaware law applies, we'll do what we need to. If not, we're gonna look at Texas law. We've got the 15th Court of Appeals, a new Court of Appeals that was created just for us. So anything I do, and I've already gone up, everything, it goes either interlocutory, accelerated, mandamus, or traditional appeal. There's 3 of them right now. They all have been Court of Appeals or Texas Supreme Court justices. So everything's being scrutinized. So we'll follow the law, obviously, and if it is a Delaware corporation, or out of the grace said, I decided to say Nevada so I don't say it wrong. We'll follow the law that's necessary. There is a Senate Bill 29 that would absolutely make some modifications, including it says something about the ability to consider or not other state legislature. I can get into that, state law, I can get into it, but I know we're running out of time. Jury trials, you do get the right to have a jury trial. Plaintiff or defendants can ask for it. In my cases, most of them have a jury trial. I'm so far set to have the first trial of all the business courts in Texas, and as of right now, it's a jury trial. They may change, they can change their mind, but they do have that opportunity and right to do so. We do not have the number of jury trials in the derivative litigation space. As far as we could find, we have one class action shareholder derivative that took place around 2000, at least 15 years ago, and a few others, so that has not been tested as much. The percentage of cases right now, more than 50%, are 10 million or above transaction. In terms of what we would consider much more of the traditional Delaware matters, shareholder derivative or governance, it's less than 20% cumulatively. So we just have more than anything, large energy transactions, construction law. It's very indicative of what you think of what the business of Texas is about. Those industries, that's what we have the most of, but we do have a cross section. In terms of the twice, excuse me?
Oh, twice tested.
Twice tested, I've got one left, according to my notes.
Such good students.
Well, no, well, we're trying, we're nerds. So twice tested. What we have to do, is there room or not? The reality is, we're not a court of equity. We've got to do what we need to do under the law. That said, many of the early hearings I've had have been TROs or TIs, so injunctive relief, i.e. irreparable injury, damages don't suffice, declaratory actions, considerations. So query, we have to, at that point, look at everything on our plate. That may not be a great answer, but it gives you a sense of, we do what we need to do jurisprudentially, but if it's an equitable remedy that we've got to address, we'll do the best we can by that as well.
Okay, Kathy. I'm sure you're thinking a lot about everything you've heard.
I'm thinking about the fact that one of these things is not like the others because I don't wear a robe, but maybe that gives me more freedom to talk.
Yeah, one of the things I wanted to ask, I wanted to get your reaction to what was said, but in addition, there was an important amendment to Section 144 of the DGCL, and there was actually a complaint by a shareholder of Dropbox, I think, saying, by legislating what can and cannot be a breach of fiduciary duty, we're really undermining the whole twice-tested approach. And in fact, the claim is that it violates the Delaware Constitution, which says that the Court of Chancery has to have the full power to test the second time, and that this is undermining that. I wonder if you had views on that, as well as just generally what's going on right now in Delaware and how that relates to the reincorporation movement.
Okay, so thank you for having me, of course. Although I went to Stanford, I'm honored to be here at the Berkeley program. I'm not going to talk in detail about how the Court of Chancery works in the abstract, because I know
everybody knows that.
I know that we actually do have a Delaware judge here who's going to talk about that right next, and I would hate to say something that's inconsistent. But I do think there are 4 key distinctions that have come out of this discussion that I want to talk about. And one is the commentators. You referenced some of the expert reports. Commentators are saying that because Nevada and Texas are more statutory, that necessarily suggests that there's going to be more predictable outcomes. And I really just don't think that that's so. Any statute, just like any contract that we write, it still requires interpretation, and the courts are still going to be called upon to interpret those statutes. And in jurisdictions like Texas and Nevada, where there is a dearth, when I went from law school in California to Delaware, I thought there was a dearth of Delaware law in most areas, other than the corporate area, but nothing like you're describing. When there's not precedent, there's going to be more interpretation of the statute that is required, and I think that's going to lead to more uncertainty. We saw that in Delaware when Delaware adopted the LLC and Limited Partnership Acts, allowed the waiver of fiduciary duties. People entered into contracts that replaced contractual, which are the equivalent of statutory, standards of conduct for the fiduciary duty, thinking that those were going to be more clear, but you're throwing the baby out with the bathwater, because when you throw out fiduciary duties, you also throw out all of the precedent. And there was more uncertainty in deciding a lot of those cases, for at least for a while, and still now, because when you're writing a statute or you're writing a contract that is going to survive for the life of these business entities throughout all the permutations and possibilities that might happen to that company, it's difficult to anticipate every scenario and the standards as written to apply those standards to every scenario. And that's where the fiduciary duty comes in the interstices, that's a law school word, between what the statute actually says. So I do think, at least in the short term, there's probably going to be less certainty for companies that move from Delaware to another jurisdiction, especially as the jurisdictions try and limit the ability to look at Delaware law as precedent. I think judicial selection is a big thing, and I'm going to start by saying I have no doubt that every judge wants to do the right thing, tries to insulate themselves from politics. But perception is reality, and given elected judges, short-term appointments, there is a risk, at least, that the perception among business people will be that decisions are being made based on politics and not necessarily based on the law. I think a 12-year term, while Delaware is not entirely insulated from politics anymore, you've referenced SB 21, I think that was more political than we're used to, but I do think I would be concerned in these other jurisdictions about the perception of politicization. Then juries, I'm going to say, again, I have the utmost respect for the jury system. But what we ask our judges in the Court of Chancery to do, and what we would be asking judges in these other jurisdictions, or juries in these other jurisdictions to do, is they're facing a case after the fact with the benefit of hindsight, knowing how decisions came out. And whether it's a fiduciary duty or a contractual or statutory standard of care, trying to decide whether the directors sitting in the boardroom when they made that decision we're acting in good faith, or we're knowingly violating a law, or we're acting intentionally. Determining the state of mind without giving effect to hindsight, and hindsight bias it's a real thing. It's how human minds work. Fighting against hindsight bias is a really hard thing. Our Court of Chancery is really good at it because they have been doing it for at least 100 years. And when you're talking about a jury of ordinary people drawn at random who may or may not want to be in the room at that particular time, I think it will be more difficult, substantially more difficult, for those juries to be able to do that when they're deciding cases that are very far outside of the ordinary course. We're not talking about ordinary negligence or personal injury, things where they might have some personal knowledge and experience. So I think that might be a little unfair to ask of juries. And then last but not least, the timing. Our Court of Chancery has a long history of being extraordinarily responsive to the needs of business. Almost a third of cases are either expedited or someone asked for them to be expedited. And our most extreme cases, if there's really a business need for a prompt decision, our court has shown that they can take a case from filing to trial in a matter of weeks. Not a preliminary injunction hearing, trial on the merits. And that requires a huge infrastructure of court personnel, clerks, magistrates, the register in chancery. And we have, just by virtue of time that we've been doing it, we have a huge infrastructure, and the Delaware legislature commits the resources necessary to keep that infrastructure up. That, I believe, will be very hard to replicate in other jurisdictions.
So I think, do you want to address my point about
Yes, I want to address twice tested because,
on SB
sorry,
21,
I think you're wrong on twice tested.
I didn't say
I think
right.
everybody's wrong on twice tested. I went back and actually read Adolph Berkeley's article.
Good.
And it was written in 1931. It wasn't widely cited in Delaware case law until the last 5 or 10 years.
I wonder who was responsible for that.
But the fact of the matter is that Professor Berkeley was reacting to a change in Delaware law from a stockholder-focused regime where stockholders had to unanimously approve certain things, where they had preemptive rights, to a regime that was board-focused. And his article was about saying, even though we're giving authority to the board to decide on a merger, we're giving authority to the board to decide to issue stock, those duties, our fiduciary duties, require that the boards do so in good faith and with care, and so we don't need to worry. The twice tested has evolved into at least some commentators suggesting that it's as if every case has to go before a judge to determine whether the fiduciaries have adequately exercised those duties. That's not true. SB 21, by its terms, it's a safe harbor for the second step twice testing. The authority to do all those things is already in the DGCL. And what 144 is saying is, if you follow these clear steps, you will be in a safe harbor. You will have met the second test. And for that reason, I think people who say it's eliminating twice tested, I think those people are just wrong. And that there is still, and I can prove it because the statute itself says that to get the benefit of the safe harbor, you have to act in good faith, that's the duty of loyalty, and without gross negligence.
So there's
that's
still room for lawyers, thank God.
I have no doubt that, as with any new statute, whether it's in Delaware or elsewhere, there will be a period of time where the boundaries and the specifics of applying that safe harbor will need to be tested in court. And I have no doubt that plaintiffs' lawyers are ready to do so. But over time, as with the duty of care generally, as with duty of loyalty generally, the boundaries will be defined, and it will hopefully reduce the burdens of litigation on corporate America, which is what we hope to do. Because litigation is not, Delaware's business is not corporate litigation. We are not establishing a regime that requires a lot of corporate litigation. I think the the speaker earlier this morning said, what we're trying to do with any regulation, as with this, is to create a regime that the people making the decisions at the time can easily follow so that there need be no, I think he said enforcement, I'll say litigation over these issues.
So, Justice, that's Stiglich. I think I'd like to dig in a little bit more on this point about predictability and, because you would remark, well, we're just going by what the statute says. I mean, the data is, there's not, as you said, there's not a lot of cases. There's also not a lot of public companies right now outside of Delaware. I think it's but basically since 1986, when Delaware adopted 102b7, at that point it went from about a third of public companies to slightly less than 2/3 of public companies being in Delaware, with somewhere around 1% each in Nevada and Texas. Looking at the one seminal precedent in Nevada, the Guzman case, which is about a control shareholder transaction, which was the heart of the recent Delaware amendment. It talks about the business judgment rule applying in that situation, and then there's very strong, straightforward Nevada statute about exculpation, which you referenced earlier. But the case, I guess there's two elements, where we could have we don't know what the outcome will be. One is business judgment still is, it's litigable. There's a concept, right? You have to act as an ordinary, prudent person reasonably would act, or something. So there's still room for grayness there, I think. It's not an automatic dismissal. And then the second is, I think the Guzman case still made it clear that the controlling shareholder doesn't get the presumption. And it says, there's language about how the controlling shareholder has to act with some kind of fairness. And so I guess if there's an argument that the controlling shareholder breached the duty, there's also we don't know where we are yet in that regard. So I'm just trying to dig in a little on this concept which was Kathy's first point, that the expert reports seem to keep saying, well, code-based, predictable. Yes, it's predictable because we know what the statute says, but what is your thoughts on that? What are your thoughts?
Well, just a couple things. Since I can't use my first favorite phrase, which is under submission, I'm going to go around just back, because you brought up, we'll get back to it, but you brought up insulation and how important it is. You want your judiciary insulated from politics, from outside considerations. We want longer terms. If we can have life terms, excellent. And yet, when Nevada insulates directors and officers, somehow it's a haven for fraud. Why don't we want to encourage qualified people to come and put themselves out there and take risks and make hard decisions and do things? So I think there's a tension there, and I think the way that we view it. With respect to Guzman, I hate to read it, again, it hasn't all been said, like I say, but I hate to read too much into it, because Guzman, as it related to controlling shareholders, largely it was a disagreement about pleadings and the way that case was pled. So I think to some extent it's a little bit of an open question about how a controlling shareholder in that position would be dealt with, and so that's the next case to come along, and that's how we do it. Yeah. So, Judge Adrogué, in Texas, again, if you look at the Tesla proxy statement, the expert there said a more code-based governance regime with more predictability. But I think, looking at the cases again about controlling shareholder transactions and disinterested directors, again, they talk about concepts of fairness. And since there's not a lot of case law, we don't know how that translates. And then one other thing I wanted to ask about was,
as far as general fiduciary duties, there's something in the Texas statute which basically says you can consider environmental and social factors. And it strikes me that's very much in tension with Governor Abbott's being one of the leading anti-ESG proponents. And, is there, I guess this is an open issue about where you are, but just as an observer in Texas, do you think there's some chance that there could be a time where actually Texas, as I understand, is one of only 2 states that say environmental factors.
Right.
Arizona's the other, right? That maybe it could go the other way, and then all of a sudden Texas is like, you can never consider environmental factors. And there's a lot, in this neighborhood, there's a lot of mission-driven companies which find the idea of being able to consider, I think, lots of factors, which is not the case in Delaware in all situations. I think you have to tie it at least to the best interests of the corporation and the shareholders, especially if you're selling the company, or if you're not a public benefit corporation. And so I guess as an observer, is that something that could be on the horizon? But more generally, on this point about code-based, or is there still a lot of chapters to be written about what is fair in a conflicted M&A transaction?
Okay, I have about 11 notes of things I'm supposed to be responsive to, and I hate not being responsive. So I will say at the outset, though, because the competitive aspect of me, when I heard the 1% Texas, do know that we follow California's home to 50, we're tied with New York for second place.
Oh, New York's
for 52 Fortune 500 companies, and Lynn Martin, which I had the luxury of meeting a couple of times. It's the state with the largest number of New York Stock Exchange listings. And I know we're getting our own stock exchange soon. That said, with seriousness, I'm realizing I did not respond to the runaway jury Texaco situation there. As has been written ad nauseum, that also was an unenforceable letter, letter of intent that query if there would have been a different instruction. Who knows? I wasn't the judge. I was not there on a legal aspect.
Right.
And so that could have been the point of differentiation. I did reference SB 29 before. Also look at House Bill 40. But on SB 29,
this is a proposal that's before the Texas
legislature. Yes, there is a waiver of jury trials for internal disputes. So corporations will be able to join LLCs and LPs, and including a waiver of jury in their governing doctrine. Right. So again, there's a lot to be, and more than anything, from my purpose, I feel poorly in that I'm not seeking not to be responsive. There's just a litany of things being asked of, and I just want, if nothing else, flag that there may be changes. We're very comfortable with jury trials. That said, know that there may be some changes, including the abilities for LLCs to have some limitations on that. So I wanted to ensure on the statutory, and although I appreciate very much that 12 years is inordinately civilized, there has been a real interest and momentum to make us, the business court judges, commensurate with the Texas Supreme Court, which would be 6 years. But we do have constitutional limitations, so the legislature and those there pick their fights, and the plaintiffs and defense bar pick theirs, and the governor picks theirs, and we will end up being where we need to be and can't do many changes there. Just in terms of, I'm trying to determine what else I want to be responsive to you. On the statutory aspect, on the fact that it is us in Arizona that we are able to look at. As of right now, the legislature allows us to look at it. Well, that's what the law is. I mean, we've got to look at the legislature. We've got to look at other case law as applicable. So if that is one of the criterion, and we are one of the 2 states that would do it, we would follow what's there.
Right.
So
I hear you.
And I don't know if did I answer? I've got many stickies. I think I'm failing to answer one or 2.
You had one more. It's like law school.
I feel like I mean, I'm in finals mode.
Okay. No, there was one more. When you have a conflict, a controlling shareholder who's doing a transaction with the company, there's all the Texas case laws. It's very general about a need for fairness. And I was addressing whether that leaves us with questions about what does that, in other words, is this entire fairness doctrine, which developed in Delaware over many years and became a subject of a lot of attacks, and that led to this safe harbor that Kathy was describing. And then that was a primary driver for companies to leave Delaware to Texas. And what I'm thinking is, well, they don't even know what they're getting in Texas necessarily, because there's a fairness requirement as well there, but they just haven't had enough cases, so we haven't developed it yet. So we don't know where we're going to be. And this is the kind of one that you don't know I don't know if anybody knows the answer to, because we don't know what the cases will show.
No, you're absolutely right. We don't know where we're going to be. Also know there is the SB 29. What we didn't discuss is they're contemplating codifying the business judgment rule. They're contemplating protecting business decisions from, as they say, opportunistic legal claims by having a minimum ownership percentage. So there's also going to be potentially some movement on inspection of books and prohibiting the recovery of attorneys' fees and disclosure-only settlements. There is so many things that we could discuss, and also allowing companies to seek upfront determination from a judge regarding the independence of directors in particular transactions, where we as business court judges would be asked to hold hearings about this in anticipation of something.
So it's amazing, because it's so dynamic right now what's going on, because you got Delaware changing its laws, Nevada has some changes, has some bills, there's important Texas bills. One thing I'll note is the Delaware, in Texas and Nevada, I think the legislature only meets unless there's a special session called every other year,
right,
for a limited period of 120, 140 days.
Yes.
Whereas the Delaware guys seem like they're constantly going, they're like enacting amendments every 2 months, which I guess keeps the lawyers on their toes. So
there's no, and I don't mean to interrupt, there's no doubt that it is very active and it is dynamic. And what's, in essence, at least the message that I would want to give is we need to adhere to the jurisprudence as it is. What's fair or not, we've got whatever's been in the Texas Supreme Court. If it's a Delaware corporation, we'll have to look at the Delaware law. So we just need to do our job. And all we're asking, there's no doubt there's amazing other platforms. You've got a jurisprudence that we at this juncture, in my lifetime, I will never get to that number, hundreds of years. So the idea is there's options, there's choices. We take our role inordinately seriously, and just like Texas welcomes its business, the business courts welcomes your business as well. I
think that's a great sentiment with which to wrap it up. I mean, this is, as they say, an experiment in democracy and in federalism. Justice Stiglich, any last remarks?
No, thank you. Thank you for having us here.
Anything that you would urge a board considering reincorporation into Nevada to keep in mind? So
Nevada's awesome. Nevada is I leave most of this to our Secretary of State, but Nevada truly is, we have a different relationship with risk than I think a lot of other states do. We have a whole city in a desert, okay? There's nothing there. Like, people come out there. It's open. It's not that it's the wild, wild west. It's not that it's lawless, but they value and want to encourage entrepreneurship, innovation, and we're open for business.
Kathy, any last words?
I would say that Delaware is a balanced jurisdiction when it comes to risk, but the benefit of a very tiny state like Delaware is that, and with our history, the corporate franchise is extraordinarily important to Delaware. And I think the results with SB 21 and the more frequent than usual amendments that you're tweaking me about is...
I think it's a good thing.
It demonstrates that Delaware is ready to be responsive to the feedback and what we are hearing from practitioners if things aren't working. All of the key players, the governor, the legislature, the courts, the bar, and ordinary Delawareans, we all understand that, and we are ready to do and committed to strengthening the franchise. I just a large state with all of the industries, probably less likely that updating the corporate franchise is going to get a lot of priority in a biannual legislative meeting. Delaware, we think about corporations day and night.
All right, these guys did put a lot in. Give them a big hand. I think they were amazing.